Ladies and gentlemen, good evening. My name is Daniel Hannan, and it's my immense pleasure this evening to introduce the cleverest man in Britain. That was a contested title until some 5.5 years ago, but I think following the demise of our friend Roger Scruton, after whom these Oakeshott Lectures were originally named, it is contested no longer. Stories of the childhood prowess of Dr. Noel Malcolm abound, but he's told me that I mustn't tell any of them. Let me suffice it for me to say that as the infant Krishna worked miracles, as the baby Hermes was said to have stolen Apollo's cattle, as the 12-year-old Jesus sat among the doctors and all were astonished by his understanding, so there are many examples of the prodigious and extraordinary genius of the young Noel. But let's start a little bit later. He did his undergraduate degree at Peterhouse, the one college that was still, and is still to some degree, holding out against the woke tide that has overcome the younger of our two universities. He then went on to be a fellow at Gonville and Keyes, and when I was an undergraduate here in the 90s, he was required reading for every conservative-minded student. His columns in The Telegraph and The Spectator were absolutely unmissable. He then began to move from being a public intellectual into a world of purer scholarship. And the transition took the form of his two extraordinary works, the short histories of Bosnia and Kosovo. And these really were works of scholarship rather than of current affairs. Dr. Malcolm took the view that he couldn't really write about either of those countries without learning all of the languages. And so he became proficient in the various languages of the South Slav peoples, of the Albanians. And in fact, I remember they were both, of course, very unpopular with Serbian nationalists, but I remember there was a continuing debate between Dr. Malcolm and a Greek academic in the letters columns of what's obviously the Greek equivalent of the TLS, in Greek, and there are not very many people who could do that. I tried to work out how many languages Noel speaks. I Googled around. One estimate said 20, one said 23. I asked him, and he came back with he reminded me of a moment at a book launch, in fact, the book launch of his Bosnia book, when a journalist from the Evening Standard was asking him about it, and Margaret Thatcher, who was present, said, "You must write something very positive about this very brilliant man. He speaks 20 languages, you know." And of course, very modestly, Noel said he wasn't sure it was that many. "We understand it to be 20 languages." And so he accepted her ruling as one did with the great lady. But I think it is rare and rather wonderful to see people who have that position of huge intellectual preeminence, being one of our leading public figures, choosing instead the path of purer scholarship. I can see a number of academics in this room, so you will know the difference between what is a good book run for an academic imprint and the average circulation of a magazine like The Spectator, let alone a newspaper like The Telegraph. The number of people who will read the great Dr. Malcolm's books on Hobbes is limited, but they will all tell you that nothing else now needs to be said about Thomas Hobbes, that this is definitive and that it will stand for decades, if not for centuries. Dr. Malcolm is now a Fellow of All Souls. His most recent book is about gay relationships in early modern Europe. 6 years ago, he wrote a groundbreaking pamphlet for policy exchange about human rights and the role of the European Court on Human Rights. And it's on that subject which he will address us now. Ladies and gentlemen, Dr. Noel Malcolm.
Well, thank you, Lord Hannan, for an extravagantly kind introduction, indeed altogether extravagant. Many thanks to the organizers, and very many thanks to all of the audience for coming here this evening. It's a special pleasure and honor to be asked to give an Oakeshott lecture. As I knew Michael Oakeshott well, my first encounter with him, admittedly, was utterly traumatic. And other people who knew him will be surprised by that, because anyone less traumatizing would be hard to imagine. But I was applying for my first job, which was a junior research fellowship at Gomerton Keyes College, Cambridge, where he was a fellow. And I was told, when called for interview, that he would question me for about 15 minutes in front of the entire college council, and then they would ask me questions. So I went in. This is my first encounter with him. And he was asking me questions about my work on Hobbes. And I think I floundered a little, but I did my best. I was troubled by how long it seemed to go on for. After a while, I sneaked a glance at my watch, and 25 minutes had gone past, not the 15 I'd been promised. I was also a bit thrown, I must confess, by a sort of verbal tic he had. If I started any sentence with, I think Hobbes' theory of natural law is really, he would lean back in his chair and say, oh, do you? And over the subsequent years, I discovered this was just a little habit. He wasn't aware of it himself. But I found it totally unknowing. I thought, this is the language of some sort of world-weary barrister destroying a witness in the witness box. Anyway, it went on for 45 minutes, and I came out a sort of quivering wreck. The next day I got the phone call, I was elected to the fellowship, and over the subsequent 7 years I got to know Michael very well. In fact, he got into a very nice habit of leaving his gown in my room, so that when he came to dinner, which was once or twice a term then, he was a full-time professor at LSE, he would always come and have a drink with me first. And so we really got to know each other well. He was marvelous to talk to about anything, not just deep issues of politics and philosophy and so on, but anything, literature, art, music. He was interested in everything. He was funny, quixotic, completely undogmatic, an absolute delight to talk to. And he had what I can only say was sort of deep charm. In fact, charm is the wrong sort of word. It might suggest something a bit superficial and a bit sort of cultivated. No, the opposite of that. I can't think of a proper word, charisma, but that might suggest a sort of demagogue on the soapbox, and he was absolutely the opposite of that. But just in his extraordinary way, he was entrancing, and I think everyone who got to know him well really loved him. And that certainly included quite a few people of the opposite sex. Michael was an incurable romantic, and I know about this mainly from Bob Grant, who is more than halfway through writing a major biography, what will be the authorized biography of Oakeshott. And Bob has plowed his way through the large quantity of personal letters, many of which are love letters. And in a way, it doesn't surprise me. Well, I knew nothing of this at the time. Michael had the astonishing ability not only to think, at last, yes, this is the one. This is the one for me. This is finally the great love of my life. Not only could he think that about one woman after another, but also, rather surprisingly, about two at the same time. Anyway, that's enough about Michael. Possibly that last bit is too much about Michael. Except just to add, he was a really deep and significant thinker, one of the great thinkers of the 20th century, in my opinion, and no time will be wasted reading anything that he wrote. But back to human rights. Well, my topic is, well, my title is The Problem with Human Rights. That's slightly abbreviated. I'm talking about, in fact, the problem with human rights law. I am not against, in any deep sense, human rights properly understood, but I'm against a whole body and system of law that has improperly misunderstood them and misapplied them. You may think, if you read the newspapers, and have done so over the last few months, that a lot of this talk will be about small boats and asylum seekers and deportation cases and so on, and that how all of that leads to the conclusion that we should leave the European Convention on Human Rights. Now, those topics are important. I'm not disputing that. There are, I think, 42,000 such cases waiting appeal. Probably more than half of those will invoke human rights issues. It is a major topic, quite rightly so, but I'm not going to be talking about that. Yes, I am in favor of leaving the European Convention, and as my talk goes on, I'll give you some idea why that is the case. But it's a conclusion I came to long ago. Dan Hannan mentioned that I wrote quite a long, sort of detailed report for Policy Exchange. I was asked to write about human rights law and the underlying theoretical issues, which I'd been interested in for many years. And it was that really brought me to the conclusion, reluctantly, that we had to leave the convention. And I say reluctantly because I'm not instinctively against internationalism. I think like-minded countries should cooperate on issues where they have shared values and common interests. I'm not against that at all. And I wouldn't want anyone to think that because I believe in a sovereign state as the best vehicle for a proper functioning democracy, that therefore I'm some sort of boneheaded isolationist. I don't think that, and I don't think that of most of the other people I know who share my broader political outlook. Nevertheless, I think we must leave, and let me just say at the outset, the small boats problem is just the tip of a much, much larger iceberg. And that's what I hope to show. And if I'm successful, you will leave this lecture shaking your heads and saying, like the Queen of Sheba when she arrived at King Solomon's court, "Behold, they had not told me the half of it." So what are human rights? Well, and how do we know what they are? There are two ways of answering that question, easy and difficult. The easy one is to say, well, we know what they are because we've got lists of them. We've got authoritative documents. The Universal Declaration, 1948, we've got the international covenants that flowed from that, and of course we've got the European Convention, 1950, set up by the Council of Europe, quite different from the European Union, and now sort of operated from its court in Strasbourg. And that's what I'm mostly concerned with, because that is not only the most fully functioning human rights regime in the world, but it's the one that we are under. We were under it since 1950, or 53 when it came into force, and now since 98 we've been under the Human Rights Act, directly under it in UK law as well. So we have documents that can answer the question, what are the human rights? But why are these given so much authority? This human rights regime doesn't directly strike down legislation. It doesn't have that power, but it is nevertheless very authoritative, although it's just an international agreement. It possesses huge moral authority. A government which has been found to be in breach of human rights will almost always make a real effort to correct the situation and become compliant. And it's not just because it's an international treaty obligation. Yes, international law imposes obligations, but it's because we're dealing here with what are apparently fundamental moral values. These are more important, more overriding. But that also means we need to be very, very sure that we've got them right. There's a popular view of rights generally, popularized by Ronald Dworkin, former professor at this university, expressed in a kind of slogan, rights are trumps. It's a card game metaphor that a right just wins, regardless of arguments that might be persuasive, that there are good policy preference reasons for not doing this or for doing something different. But if it's a right, that right simply takes priority because it's a trump card. So the idea, the mentality is anti-utilitarian. You don't have to go through the normal process of working out what would be the best policy. I mean, you might if you like, but if you find it conflicts with the right must take priority. Again, this means you've got to be very sure. So what are these rights? Well, if you look at the Convention, it's a familiar list, Articles 2 to 12, the right to life, not to be tortured, not to be held in slavery, and so on, fair trial, respect for private and family life, freedom of thought, freedom of expression, freedom of association, the right to marry. So it's a good basic list. And then others have been added subsequently in add-on agreements, which are known as protocols. Take a typical article, and you'll find it's stated in two halves. The first half states, so to speak, the pure right. So Article 8 says, everyone has the right to respect for his private and family life, his home, and his correspondence. That's a very simple, abstract, pure statement of the right. Then the second half sets out the conditions under which you could interfere with that right or limit the exercise of that right. And these are known technically as the limitations. So there shall be no interference with it except as is necessary in a democratic society in the interests of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, protection of health or morals, or the protection of the rights and freedoms of others. So there's a great list there of very broad purposes, goals, values, in some cases sort of policy interests, protection of health, public safety, economic well-being. And these, it says, can be invoked as justifying reasons for limiting the exercise of the right. So what you're looking at when you take a typical case that goes to the Strasbourg court is actually a complex balancing act. Almost every time, they're trying to reconcile the pure right with the degree to which some of those factors, and there could be multiple factors engaged in any particular case, the degree to which they countervail. How much interference in that right, say the right to privacy, private life, is justified by national security? Very important question in many cases. How do you justify this right against that in terms of economic well-being? And so on. So one thing should be blindingly obvious immediately. Rights are not trumps. They're not get-out-of-jail cards that just immediately solve the issue. On the contrary, these human rights are enmeshed in interests, policy goals, values, all the sort of messy things that go into political decision-making. In fact, they are essentially political issues. So the popular idea that human rights judges are like sort of white-coated lab scientists, the experts with their special skills in working out just a little bit more of that right and a little bit more of that. No, that's not what they're doing. This is not a pure science of any kind. It's not a moral science. And these judgments that they issue in court are very unlike the sort of technical applications of settled law that you might find in a normal court of law. They're much more like political decisions. They're infused with values, and they depend in the end on underlying assumptions about what is a good life for an individual or what is good for society at large. So two key points I want to emphasize. First of all, there's obviously not a pure science of human rights there. And secondly, because it's mixed up with all these other messy goals and values and so on, it overlaps in many, many ways with what democratic politics does. So both these points raise questions about the special authority of human rights law, which I mentioned at the beginning, that special moral authority that makes us feel, well, we must bow to it, we must correct our arrangements in the light of a judgment. What about democratic politics? Surely we would start with the assumption it's good that democratic politics should be in charge of many issues, especially when they're hard to decide and when the decisions depend on assessments of values, not on scientific reasoning. Cases where reasonable people can reasonably differ. We resolve those in a messy and no doubt suboptimal way through representative democracy. And the point is we get a result which, because it's been through that process, people can accept for that reason. It gains legitimacy because of the democratic process that it's been through. Now, on the side of the human rights lawyers, there's a standard, rather hackneyed argument. So, oh, well, if you allow Parliament to decide things, this risks the tyranny of the majority. That's a bit of a slogan, and it's often based on a very crude sort of caricature of what democratic politics actually does, as if it was just what's known technically as interest aggregation. You know, more of us prefer this, therefore this is right, and therefore get lost. That's hardly ever how major complex issues are decided in a representative democracy. And there's actually a brilliant book on this issue, which I recommend to those who want further reading, by Jeremy Waldron, also former professor at this university. It's called Law and Disagreement. It's quite old now, but I think the central arguments are still hugely stimulating. Now, of course, if Parliament voted tomorrow to abolish freedom of speech or freedom of assembly, yes, of course, we'd been in trouble, and we'd say, well, what tyranny of a majority caused that? But that's not how it works. And what one is dealing with is specific, difficult cases that may come up for legislation. And the real issue is, to put it in human rights terms, about those limitations, about those countervailing factors. how should we assess the claims of national security against the claims of individual privacy and so on? What are public morals? How far should their claims extend? These are things that, precisely because there's no science, I actually think it's better that they should be decided by rational debate in Parliament, which often, think of something recent, quite big, the long-running debate on assisted dying. You know, we have civil rights groups, we have lobbying organizations, we have discussion in the media, we have people going away and consulting philosophers. It's not interest aggregation, it's something very different, and it's something that Parliament, at its best, actually does quite well. So there is a question to be asked about this human rights law and how it relates to democracy. Is it undermining democracy if increasingly the difficult issues are taken away from the scope of Parliament and handed over to the judges in the court, whether in Strasbourg or in the Supreme Court in London, which is charged now with applying this law directly? Is human rights law a threat to democracy? So the defenders have two standard replies to that. One is, well, that's absurd. It can't be, because look at that list of human rights. They include freedom of expression and freedom of assembly. These are absolute pillars of democracy. Therefore, on the contrary, this is the fundamental support for democracy. Now, I think that's a footling answer, because it's perfectly possible for a great list of things to contain some things that work for something and others that work against. But the point is not what the other things on the list are anyway, it's the whole nature of the development of this body of the law and the way it's been gradually encroaching on the scope of what was previously up for parliamentary discussion and legislation. So that's the first standard defense. The second one, here I have to get into a little bit of technicality, is something called the margin of appreciation. And the idea here is that the law in Strasbourg allows for a sort of leeway of national discretion for national parliaments or national judiciaries to sort of make their own decisions that might vary a bit, and but at least they're in touch with their local circumstances, and so they're allowed this discretion by the court. Margin of appreciation, strange phrase, it's a mistranslation or a sort of non-translation from marge d'appréciation, where, as I'm sure you know, appréciation doesn't mean appreciation, it means appraisal, or we might say assessment. It's a margin of assessment, and the local authorities are allowed to assess things with a little bit of freedom. But what is this margin of appreciation? There's a sort of body of theory about it which has established only one thing, which is that there is no clear theory at all. It's a theoretical mess. It's been justified and applied in a dozen different ways in different keynote judgments. And there are often cases where we're told there are sort of 6 factors you have to consider. And if this one is stronger, then the margin of appreciation is expanded slightly. And if that one is weaker, it goes down a bit. If it's on this sort of subject matter or that article of the convention, it goes right down. If it's on that, it comes up again. There's never been a coherent theory of this. One element in the standard accounts is a doctrine of consensus. If there's a European consensus, then that narrows the margin of appreciation for a country that goes against the consensus. So the basic idea there, if lots of countries don't allow X, then the country that's saying, oh, we want to allow X, has a smaller margin of appreciation, or perhaps no margin at all. But how does this work in practice? Look at the judgments they've given. Sometimes they're so eager to say that there is now a consensus that 51%, it's just tipped over because one country has changed its laws, suddenly say, well, there's now a European consensus and your margin of appreciation has vanished and you've got to do this. They did this in 2015 in the Oliari case, which was to do with same-sex marriage in Italy, where the Italian parliament had resisted such a reform. But then in other cases, famous case in Ireland, an appeal against the then draconian anti-abortion laws in Ireland, they said, well, it's true that 41 out of 47 countries have a much more liberal regime. That's 91-point-something%. But no, that doesn't create a consensus, and Ireland must be allowed its margin of appreciation. So there is no consistency at all. You might ask yourself, why were they so generous to Ireland, being extremely traditional on this? The answer is a pure political fudge. They didn't want to offend the handful of ultra-Catholic countries in the Council of Europe that still stuck to a very strict anti-abortion rule. So you just don't get any clear guidance from this. Of course, if you're the only country that does something, they will tell you that this eliminates the margin eliminates the margin because there is such a consensus against you. This happened to the UK on its policy of keeping DNA samples of suspects indefinitely. Okay, we were in the minority of one, but it's a little funny to think that the same people who defend this system are the ones warning about the tyranny of the majority. Two deeper problems about how this law is applied. One, I'm sorry, I have to be a bit technical again here, but it's important to get a sense of just how strange some of this doctrine is. The doctrine of proportionality, which dominates so many judgments, basic idea seems reasonable. Those limiting factors should be kept, the limitation of an actual exercise of a right should be kept to a minimum in practice. So if you do have to interfere with a right, you should interfere just enough to satisfy the requirement, but no more than that. Well, it's nice to say that in theory, but how do you know in practice, in any particular concrete circumstances, what is just enough? I mean, the answer is in most cases you don't. And the public authorities that have to make decisions at the time don't. They only find out when they're taken retrospectively to court and then told that they were in violation of human rights. That happened to the police in London, the famous Osman case, which involved a mentally deranged man who ended up killing someone. And it was said on a doctrine of proportionality, they had not done enough, the police had not done enough to protect the prospective victim. Well, of course, they didn't know he was going to be killed at that stage, and they did offer some level of police action. But this means that the police never know quite whether they're satisfying the law or not. Previously, we had a reasonableness test in UK law called the Wednesbury Rule, marvelously phrased, if I can get it correctly, that you have to show that the action of a public authority, a decision, was so unreasonable that no reasonable person acting reasonably could possibly have made it. Well, that sounds funny, but it's actually quite sensible, and it worked well in practice. It set out an area of discretion for the police, for local government, and so on, to carry out their policy duties within a reasonable remit. Now they've got to try and get it absolutely spot on, and of course they can't because they're not given the guidelines that would enable them to calculate that. And the latest example, which may have a large effect on our lives, just a year ago, Ziegler, which involved a protester sitting down in the road, blocking the traffic, arrested for obstruction, absolutely clear violation of the Highways Act, charged and convicted. This was taken to court, and they found that it was unsafe and indeed a violation because they had not shown that the infringement of his personal liberty that consisted in grabbing him off the highway and then charging him and so on, that this was proportionate to the particular level of disruption that he was causing, given the various other factors that had to be taken into account about why he was causing the disruption, who he was causing it to, so on and so forth. I mean, from that moment, no policeman knows, when trying to deal with a situation like that, whether they're breaking the law themselves or not, committing a violation of human rights when they try to do their duty as a police officer. So that, I said it was technical, but that gives you a sense what's wrong with, potentially wrong with this proportionality doctrine. The other problem is more major. It's rights expansion. That over time, the number of rights and the nature of the existing rights have just grown and grown and grown. Now, when my policy exchange pamphlet came out, I was put briefly on the Today program to talk about it, and they put up against me Helena Kennedy, who was there to trash my opinions. She obviously hadn't read what I had written, which you might think had put her at a disadvantage, but she didn't see it that way. And she just said, don't listen to this man. He's not a professional lawyer. He doesn't realize, as we lawyers do, that all law develops. And I wasn't allowed to answer her. The next question to me was on something completely different, and then they ended the discussion. But I wanted to say, well, first of all, I do know about how law develops. I have a whole section in my study on that problem. But secondly, to say all law develops is completely irrelevant. This is a very special category of law. This is the law that is concerned with interpreting a treaty. The European Convention is a treaty, and there are rules about that in the Vienna Convention on the Law of Treaties, and they say what is legitimate interpretation and what is not. And it is clear that the judges in Strasbourg over the years have gone way beyond what is legitimate according to those rules. So back to Article 8, private and family life, the home and correspondence. The home, we've been told now, means business premises, an office. Private life now means business activities in the office. Many other examples. Family life now involves the right of a prisoner to father a child by artificial insemination. Well, that might be a humane measure for a government to bring in its ordinary legislation, but why on earth should that be a matter involving claims of human rights violations if you don't? The case Nimitz, 1992, which said that the home included business premises, it said, to interpret the word home as including business premises would be consonant with the essential object and purpose of Article 8. And there you put your finger on a fundamental thing, resort to claims about the object and purpose of actually very specific wording. They don't confine themselves to the wording, they invent a much larger purpose, and then they draw their interpretation from that. But there are other kinds of rights expansion, lowering the thresholds of key terms. So Article 3 against torture and inhuman and degrading treatment now includes all sorts of things that were not in the minds of the people who drew that up soon after the Second World War. They've lowered the threshold for inhuman treatment, so it includes spending a bit too long in a crowded reception center on a Greek island when you've just arrived from Turkey on a small boat. They include any excessive force against any person in custody, one slap on the face in one case that was decided as a human rights violation, one unnecessary use of handcuffs was now a violation of the human right concerned with torture and degrading treatment. Then there are cases where they've just changed the nature of the right. So Protocol 1 brought in, for the first time, a right to do with elections. And it just said, the phrasing was unusual, it said, the states undertake to hold free elections. That was the wording. It was not actually framed in terms of individual rights at all. And that was deliberate, we know from the discussions in advance. They didn't want to say there is an individual right to vote, because that might lead into complications. There are particular cases where you disqualify people and so on. But not many years later, the court just said, well, actually, we must interpret this as meaning there is an individual right to vote. And their judgment on that actually said, we must interpret it that way, I quote, regardless of the wording of the article. Now, I'm not a professional lawyer, I'm certainly not a judge, but I think we're all entitled to feel a slight frisson when we read judges saying, regardless of the actual wording of the law. And it was on the basis of that that we then had the famous prisoners' votes case that David Cameron said made him feel sick to the pit of his stomach, and that was a huge political issue that went on for several years in this country. But best of all, and this again is almost breaking news, very recently we had the case decided in Strasbourg of the Verein Klimaseniorinnen, which roughly translates as the Association of Climate Old Ladies. And these were, it was an association of climate-concerned citizens in Switzerland, female and above a certain age, who brought a case under Article 8 again, that their home and private and family life was under threat, was being violated, the respect to it was being violated by growing temperatures. And the Swiss government had had a target a bit like ours for reducing CO2, and it had failed to meet the target, and then it had lowered the target slightly. So instead of reducing by 20% by a certain date, it said, well, okay, we've actually only reduced by 10%, and then they sort of tried to recalibrate. So they were taken to court on that as a human rights violation, and the court found in their favor. So it is a human rights violation for a government to fail to meet some quota of CO2 reduction, which it had actually devised in the first place. The judges at Strasbourg are not climate scientists, but there are larger questions you might want to ask as a matter of common sense. One question would be, well, actually, what percentage of global CO2 emissions is actually produced by Switzerland? Have a guess. 3%? 2%? It's 0.09%. And the failure of the Swiss government was that it had failed to meet a target of reducing by 20% and only reduced it by just over 10%. So we're talking about a gap of 10% of that, which is 0.009% of global CO2 emissions. I doubt whether the most sensitive marmot on the Swiss mountainside could possibly tell the difference if the temperature had gone up or down, assuming there's a linear correlation between temperature and these emissions, which I think is still another matter for discussion. But that is what we're now living with. This is a landmark decision that climate change can be immediately, directly a violation, a factor that leads to a violation of human rights. And then finally, what's behind all of this is the living instrument doctrine, which developed at the court in the 1970s, that this is a living instrument, unlike other treaties, unlike other bodies of law formed on a similar basis. And it's got to develop all the time. Now, that is based, to a large extent, on a crude misreading of the preamble, which talks about the further realization in the English version, further realization, in the French version, the développement of rights. But the subject of that sentence is the Council of Europe, it's not the court. And it's just part of a background statement. The Council of Europe has brought in these rights in 1950, and it aims to go further and in future to bring in more rights, and won't that be a good thing? It's nothing to do with the court itself in its judgments, expanding the rights that are on the list, which it is its sole job to scrutinize as they stand on the page and apply. But this has authorized, in their minds, a teleological approach. I quoted earlier that thing about the essential object and purpose of an article, but they now talk about the whole convention having a purpose to protect, and I've just plucked out of a number of judgments, take all of these in inverted commas, human dignity, psychological integrity, the development of the personality, personal autonomy, respect for human dignity and human freedom. Well, these are all marvelous things, but they don't occur anywhere in the text of the convention. And you feel you have to hope that some people in this court are capable of reasoning in terms of sort of simple syllogistic logic. It may well be true to say that everything protected by the convention is to do with respect for human dignity and freedom. It does not follow that everything to do with human dignity and freedom is protected by the convention. So the underlying assumption here is that there is a great sort of moral purpose that transcends the actual wording of the text, and that this is what the judges are really there to do. Now, it's inevitable, if that mindset exists, that it will erode democratic decision-making by parliaments on key policy issues, because they feel they have a far superior entitlement. If they had some perfectly demonstrable moral science behind all of this, well, then they might be able to argue their case, but it's clear that they don't. And what's worse is that in carrying out their legal development of this kind, they're failing all the basic rule of law tests: clarity, predictability, knowability. Increasingly, people just do not and cannot know whether a particular borderline action will be or will not be a human rights violation. And as this goes on, it increasingly undermines the democratic decision-making, which for me was the basic reason why I thought we had to leave. So just in the last part of this talk, I want to come back to that basic question, what are human rights and how do we know what they are? I began with the easy answer, which was we look at the lists. And I proceeded on that basis and talking about the court, which has its own list, even if it strays way beyond it quite often. But now I'll try to answer the question the difficult way, which is, in some sense, the philosophical way. What is the nature, scope, and purpose of these human rights? How do we know what they are and where they are, so to speak, in the abstract? Something I noticed when I was doing the work for my pamphlet, well, I call it a pamphlet, it's actually a short book, for policy exchange, and I plowed through in the law library endless treatises on this subject by very eminent and respected authorities. There is no agreed theory. There is no satisfactory account of exactly how these things arise philosophically, what they're derived from. Certainly not any generally agreed one. Now, you might say, well, the same is true about morality. There are lots of competing theories of that. Well, yes, fair enough, but we don't live under a special category of law called morality law. We do live under a special category of law called human rights law. There's a famous story about Jacques Maritain, the famous Catholic philosopher who was involved in the original putting together of the European Convention. And he once said, yes, we agree about the rights, but on condition that no one asks us why. And that is a sort of reasonable formulation of the theoretical underpinning of this project. There are various theories of human rights, no generally agreed ones. The standard assumption is we've got to get to work in the realm of moral philosophy, moral theory. And they're human because they come from the nature of humanity. We've got to look at human nature and somehow derive from it the special rights and corresponding duties that we call human rights. And various theories have been tried out, some at length, based on human rationality, or the concept of autonomy, personhood, dignity, some reduced to a single master value, some offer a sort of a la carte menu, or well, not a la carte, but a sort of list of things that they say are the essential ingredients, but not combined in a single sort of value. Some say, oh, well, it's really to do with fundamental human interests. So, the interest in, subsistence living as a minimum and things like that, or the interest in respect for one's personality or whatever. Things that it can be stated at a sort of pre-moral level, and then this moral value comes in when you try to find a way of fulfilling and maximizing them. For the philosophers here, I think it's an interesting project, but it's strangely similar overall to utilitarianism, which is famously hostile to the concept of rights in the first place. I can't go into this in detail. Let me just summarize. There is no satisfactory solution produced by any of these various theories. They don't produce this rather peculiar list of human rights, which is an odd combination of some positive rights, some negative rights, some very plainly sort of civic stroke political rights, the right to a fair trial. You're not going to get that just from, thinking about human beings in the abstract. Well, there are some ways you could get it, but you're not going to get the particular combination of rights that have turned up on these standard lists. And then if you do manage to generate all of these things, you'll probably succeed too well, and you'll end up generating the whole field of morality. I mean, that's what a sort of Kantian theory would do, or in its own special way, utilitarian theory would do, or a Catholic Thomist theory. And then what do? You've got all sorts of moral rights and moral duties. How do you distinguish the ones, so to speak, at the top of the list, which are the special ones which count as human rights? There is quite a common tendency to do this, have a sort of ascending scale of morally important things, and then just say, well, then there's a threshold, and above that, the most important things are the human rights. I've never seen a satisfactory explanation of that. What criterion gives you that threshold? I can think of really important things quite high up the scale that don't come into the field of human rights at all. If it's the importance of the interest at stake, what about the interest in being loved? Fundamental to most people having a satisfactory life. It's got nothing to do with human rights. What about, or if it's to do with measuring the moral wrong of an infringement of someone's rights, if you can call them that, there are all sorts of scenarios one can think of where huge wrongs are done that don't necessarily involve what we would call human rights. Imagine a loving, self-sacrificing single parent who's worked herself to a bone, sacrificed all sorts of things to bring up her son, and then he disowns her and treats her with cruelty and spite and so on. I think that's one of the most morally horrible things that's one's likely to come across in ordinary life, but I don't see anything there that would have anything to do particularly with human rights. She's not going to take him to court, at least not to Strasbourg. And then there are other problems, the universality idea that all rights, if they're human, apply everywhere and have applied always. So there's human rights we're applying in Neolithic Africa and Ming China and medieval England and so on. Really? Right to free and fair elections, fair trials? So the theorists struggle to bring in a bit of sort of quasi-cultural relativism or historical relativism to try to cope with that while continuing to say, oh, it's all based on humanity in itself in the abstract. Doesn't work. So my proposal is let's stop trying to solve this problem on the basis of moral philosophy. Let's look instead at what these rights actually are and how they actually function, what they're there for. They're there against the state. That's a fundamental point. And it's obvious when you think about it, when you look at those rights, and you look at the whole process of drawing them up in the late 1940s, in the aftermath of the Second World War, and after the totalitarian regimes, Nazism, fascism, and while they had a growing awareness of life under Stalinism, it's about the misuse of state power. So we don't get there by starting off at ground level in moral philosophy. We need to think politically. And actually, everyone knows they're against the state because this is how they use the language. If someone's car is stolen, we can say she's been wronged. There's a moral wrong, there's a legal wrong, but no one says there's been a human rights violation, although Protocol 1, Article 1, guarantees the right to private property. However, if mysterious balaclava-masked agents of MI5 came and took her car, we would then start saying we thought there was a human rights violation. I mean, it's common sense. We know this in the ordinary way we use the language. And all the things on that list are actually about cases of the state abusing its power vis-à-vis its citizens. It's the duty not to kill them, not to torture them, not to arrest them arbitrarily, to let trials take place fairly, to let people express their opinions, gather in public meetings, and so on and so on. I mean, that is obviously what it's for. They're the minimal requirements we make of states. They're mostly negative, don't torture us, don't oppress us in this way or that, but also some positive, not so much in the European Convention, but the international covenants flowing from the Universal Declaration have things like the right to, basic standards of living, basic health care. And for decades, people have accepted, well, that's a reasonable thing to put in a Convention of Human Rights, and many countries have signed those covenants, including our own. So those things are there, not because you derive those from fundamental moral philosophy, but because you know that in a modern democratic state, this is now part of the minimum that people expect of the government. And the government that lets people starve in the streets or sort of die of horrible diseases lying in the gutter is, in our opinion, falling below the minimum level that we expect of a government. So my basic point is a simple one, I think. They are actually statements about the minimum conditions of the legitimacy of the state and of the exercise of state power. If it tortures us, if it holds us without trial, and so on and so on, it loses legitimacy. I'm talking about modern states, I'm talking about democratic states, because I think a democracy involves this particular sense that we entrust power to our rulers on the basis of certain expectations which we have of them. I would apply it to what I'd call would-be democracies, modern states where people want to live in a democracy, but that's not quite what they've got. Perhaps Iran today would be an example of that. I would not apply this to many societies in the past that were not democracies and were not even worrying about the fact that they weren't democracies. Now, I don't know if it's historically true, but let's say, for the sake of argument, that 120 years ago in Tibet, you had a contented population who were very happy to live in a theocracy, or, well, maybe a hierocracy, I'm not quite sure. And they wouldn't have wanted democracy, and they were happy with what the limited amount of things that the lamas did for them, and so on. You wouldn't say they were suffering terrible human rights violations just for the fact they didn't have free elections or this or that. I just think the term is specific to democracies or would-be democracies, and therefore it's historically fairly modern. It's an absurd exercise, I believe, to go back and write about Aztec emperors engaged in human sacrifice and say, oh, well, we've got to bear in mind these are terrible human rights violations. Of course we can all feel as human beings these are terrible things, horrible breaches of elementary human morality. I'm not denying that for a moment. But the concept of human rights is a more specific, modern political concept. And human rights are essentially a sort of program of claims that we make on the government. So that's my alternative way of constructing the whole theory. What are its advantages? Well, first of all, it gets away from the impossible task of writing a sort of textbook demonstrating the nature of morality from the ground up. For political purposes, it's enough to know that the people have these demands. Now, why do they have them? Not least because they have strong moral views and they think it's morally wrong to torture. I'm not trying to separate this from morality. On the contrary, I'm not denying the objectivity of morality as far as one can establish that. I'm just saying that the mere fact of being morally important is not itself what makes them human rights. It's the fact that they constitute these special claims on government by the citizens of a democracy. So that's one advantage. Then I think it avoids the problem of trying to construct a priori why it's just this list of important things and not various other morally important things that might get onto the list. The threshold problem. We don't have to worry about that. We just know that in our society, certain things are regarded as intolerable if the government does them or if it sort of completely fails to provide certain things. That's enough. It avoids the problem of timeless human rights for people going back through the millennia. I think I've explained why it does that. It helps to explain the contingent fact, but, well, it's not contingent. I think it's a revealing fact that human rights as a concept are historically very recent things. It deals with the fact that our list of human rights is a rather messy combination of negative rights and positive rights, and freedoms, some of which are freedoms from in a sort of passive sense, like freedom from torture, others freedoms to, freedom to express, freedom to assemble. You know, it's a complicated, slightly messy combination of categories, but that's a problem for many other theories. It's not a problem for me. I can just accept them as they come. It deals with the fact, which I think is so obvious, these are state-regarding, they're state-directed. The moral philosophical way of approaching it can talk about the right not to be murdered, but as I said, it's absurd, as with the stealing of the car, it's absurd to say, oh, you know, so-and-so was murdered the other day, that was a human rights violation. We only say that if it was the state. And it deals with the fact that some of these rights are actually privileged to citizens. My argument really is that these are slightly misnamed as human rights. They are fundamental democratic political rights. And that's the thing that lies at the heart of my argument. And therefore, finally, it emphasizes that the whole point of human rights is that they're bound up with democracy. They're, so to speak, structural principles of a properly functioning democracy itself, essential requirements of democratic rule. So wherever you have a democracy, you must have human rights. Now, how far you wish to entrench them in a special legal regime, that is a slightly secondary issue, but I think it's important we should recognize them as important, and I'm not against giving them some special role, but if they were going to be given a special role, I would want them to be properly specified as prohibitions on government, and the whole wording would be turned the other way around. State power and its agencies shall not, ... And if necessary, go into a reasonable amount of detail on that. Don't just put out these completely open-ended abstract nouns and expect judges to sort of stick closely to them. They won't. They'll go off in 101 different directions. But this also means that if human rights, as I believe, have a special relationship to democracy, those who care about human rights have a special duty not to use those rights to undermine democracy or to take from democratic decision-making the things that should be dealt with by democratic lawmaking. Government should be carrying out a whole range of proper functions, and they include centrally the making and implementing of laws. On what field of things? Well, difficult here to set out an a priori scheme that will cover everything, but I think as a starting point, one would say almost any significant issue where reasonable disagreement can take place among people of good faith who have a reasonable grasp, reasonable understanding of the relevant facts. So when a human rights regime is seen decade after decade to draw areas of decision-making away from the democratic legislatures and make them the preserve of judges, and especially when those judges are operating with a very unstable mix of partly subjective principles, conflicting criteria, there must be serious cause for concern. To undermine democracy is, in a particular way, to undermine the very system of legitimate rule which human rights are intended to preserve. So let me give the last word to Pierre-Henri Tédijan, probably not a name you're familiar with, one of the unsung heroes of the 20th century, a French lawyer from Brittany. He was in the French Resistance. He later was a French law professor and then a minister in the government. He was one of the founders of Le Monde, and he became the chief rapporteur of the group that drew up the European Convention. And when he presented the first full draft to the Council of Europe in late 1949, he said, "The committee unanimously agreed that for the moment only those essential rights and fundamental liberties should be guaranteed which are accepted by long usage by democratic regimes. These rights and liberties are the common denominator of our political institutions, the first triumph of democracy, but also the necessary condition under which it operates. That is why they must be the subject of a collective guarantee." So that, to go back to the teleological language, if you want to know the real object and purpose of the Convention, there you have it in print. It was not to enter into the nooks and crannies of ordinary life, not to serve as an all-purpose device to correct minor injustices here, there, and everywhere, and not to develop questionable doctrines designed to permit the ever-expanding growth of rights at an ever greater level of detail. And above all, not to undermine democracy by taking more and more areas of policy-making out of the hands of democratic legislatures. On the contrary, it was intended to strengthen democracy itself. And it's because it has failed to fulfill that purpose that I now think, and with, as I said, some reluctance, but I do think that it's time to leave. Thank you.
Well, Noel, thank you very much. I'm sure I speak on behalf of everybody here. That was a wonderful tour d'horizon. I wonder if I might just tempt you onto slightly more political territory and put to you some of the arguments that are most often advanced by the Helena Kennedys who haven't read your book. And the first one that one gets all the time is, this is really about setting an example. Britain may not have a long history of torturing people or seizing their property without due process or deporting whole populations, but what will the Sorbs or the Ruthenians or some other benighted people think if they watch us withdraw? Now, you've spent quite a lot of time among Sorbs and Ruthenians and all the peoples in between. Are they hunched over their newspapers in Tirana saying, "Oh my God, the British are thinking of leaving the ECHR"? What would be the impact?
Well, I think there probably would be some impact in sort of publicity terms, but mainly driven by hostile comment by people on the other side of the argument, massively exaggerating the significance of this, or indeed the mentality, misdescribing the mentality of those who argued for it. I mean, the basic suggestion that we must stay in a failing institution because it would somehow be bad for morale for others if we left, or that other people would follow us. Well, I mean, if we think it's right to leave it, we're not in a strong position to say it would be wrong for them to follow us. But I don't think they are concerned with following us in any case. In previous years, when these conversations occurred, everyone said, "Oh, but this is awful." And then, Russia could then leave and say that it was just following the example of the United Kingdom, and that would be shocking and disgraceful. Well, that problem has slightly taken care of itself with Russia in the Council of Europe. Though actually, I would just
striking also that almost all of the abuses of state power under Putin, the establishment of a one-party state, the repression of the opposition, happened while Russia was a member, without there being any apparent deterrent effect at all.
Indeed, yes. I mean, as I said, the authority of the system to get some kind of enforcement is in the end just moral authority. I mean, yes, at the level of international law, there's an obligation, but that is water off a duck's back to someone like Putin. Actually, it's interesting, the estrangement of Russia from the Strasbourg court happened quite a long time ago. 2010, there was a case where the extremely generous maternity leave to female soldiers in the Red Army was claimed by a father who wanted exactly the same amount of paternity leave. I mean, I say extremely generous, 3 years. And this was taken to Strasbourg, and the Strasbourg court said, the Russian Constitutional Court had looked at it and said, well, there are special considerations in the case of the mothers, and therefore we're justified in having a different regime for the fathers. The Strasbourg court issued a very patronizing judgment saying this Russian judgment is just an exhibition of gender prejudice, and they must change their law so that fathers can also have 3 years. This didn't go down well, and the head of the Russian Constitutional Court at the time, who I think was not a particularly a Putin poodle, took umbrage at this and said, well, in future we'll think very carefully about how far we want to obey this court. So, the idea that just our leaving is going to dictate the behavior of other countries is, I think, just a convenient fantasy on the part of those who have other reasons for not wanting us to leave.
So what about a parallel argument that this is really about British diplomacy, that in the world of 1948 or 1950, what we understand by basic freedoms, the elevation of the individual above the collective, the rule of law, due process, was really confined to the Anglosphere and a handful of hither countries in the northwest part of Europe. And that the ECHR, although it simply restated a lot of standard practice for us, was a big deal for some of the countries whom we were, if you like, encouraging to be more like us.
I think there's truth in that when you look at the expansion of the Council of Europe over the years, and when countries such as Azerbaijan or Moldova came into it, as with applicant countries to the EU, there's a sort of cumbersome system of scrutiny and all sorts of things that need to be improved. And there are studies, as you will know better than most, about what happens in applicant states. And I think the studies show that people do genuinely try to pull their socks up in the application process. They stop pretty quickly once they're in. But that's a parallel case. Of course, EU is nothing to do with this, at least in no direct way. So there may well be some sort of moral improvement and brushing up of systems and improvement of rule of law practices at certain levels, fair trials and so on, in order to qualify for membership of the Council of Europe. But beyond that, the idea that, I mean, we go back to a certain patronizing mindset that one used to find in the British Foreign Office, and there are sort of pockets of it still, that yes, really, it's our sort of mission civilisatrice to sort of show these foreigners how best to conduct their affairs. I think the idea that they're all sort of modeling themselves on us, and behind that, the idea that the convention was itself a British invention, which is a myth put about constantly by some people in this country who very much don't want us to leave. There's a large element of wishful thinking there.
Yes. Another, I mean, there may be wishful thinking in this as well, but one of the arguments that one hears constantly now that, two of the three biggest parties in the opinion polls are for withdrawal, is that this would destroy the Belfast Agreement, that the relationship between the UK and Ireland, not just the Windsor framework, but everything going back to the 1998 deal, depends on both countries being signatories to the ECHR or adherence to its principles, that you'd be taking the keystone out of the whole arch. Now, that to me sounds like motivated reasoning, but I'm conscious that, what Suella Braverman says may sound like motivated reasoning if I were on the other side. What do you think what would be the impact legally if we were to withdraw on our relations with our one land neighbour?
Well, certainly until recently, it was an absolutely accepted standard view that it would disrupt the Good Friday Agreement and therefore would be a terrible thing for Northern Ireland. It was repeated from mouth to mouth, rather in the way that people in the Biden administration repeated all that stuff about how a hard border would destroy the Belfast Agreement. There was nothing about hard or soft borders in the agreement. But as it happens, within the last year, or less than a year, I think, we've had 3 quite detailed investigations of this. A pamphlet by Peter Lilly, a more detailed pamphlet by the wonderful Professor Richard Eakins of this university and 2 of his colleagues, and then a very thorough examination, drawing partly on Eakins and his colleagues, by Lord Wolfson, Shadow Attorney General, quite recently a big position paper for Kemi Badenoch. And they've gone into this in detail. I mean, as you know, the agreement, what we call the Good Friday Belfast Agreement, is two separate things. There's the Anglo-Irish Treaty, and that's a proper international treaty. And then there's the multi-party agreement, which is an agreement between political parties, Dublin, London, and so on, which is not a treaty and has a rather different status. The treaty itself has no reference to the European Convention, but it does say, as part of the obligations of the treaty, they will support the multi-party agreement. The multi-party agreement does refer to the ECHR at several points. But if you look in detail at what it says, none of those points would be invalidated simply by our ceasing to be a member of the European Convention. It does require us to incorporate the provisions of the European Convention in Northern Ireland law, and that was done. And as long as that remained, essentially that would be the central issue, and there would be no complaint over that. I'm sure because it's a contentious issue and because many, many people will just seize at a chance to say that the next government, if it is reform or conservative or some combination of the two, seize on the chance to say that it is sort of destroying rights and it is tyrannical and so on. They will exaggerate as much as possible any negative aspects of this. And there may be cases brought in Northern Ireland, but from these detailed legal analyses, it seems clear to me that there is no reason for thinking that this would actually break the Belfast Agreement at all.
I wonder if I could take you back to the lockdown. I mean, I was very struck when you were talking there about the expansionist way in which these judgments are increasingly being made on the basis of what the judges think the law ought to say rather than what it says. The right for prisoners to father children, the freezing Swiss marmots, the right not to be overcrowded when you enter Europe illegally. Britain, prior to 1950, was not in the habit of violating these rights. You know, we were pretty much the definition of a country that didn't, we and the other Anglosphere states. So we weren't given these rights. You know, as Aldous Huxley says, liberties are not given, they're taken. I can only think of one occasion in my life when there really was a mass violation of what I think of as basic human rights, and that was in March 2020, when we were forbidden to enjoy our property, we were forbidden to travel, and we were effectively confined to house arrest, something which in law normally requires an extremely high threshold, but which was done on the basis of the flimsiest of evidence, which later turned out to be erroneous. And this is what really struck me. The one time that there really was a mass removal of human rights, the thing that the ECHR authors were conscious of protecting against, where were the cohorts of human rights lawyers? With the exception of Lord Sumption, they were almost all cheering it on. And I wonder whether that doesn't slightly change the whole parameters within which this debate is being conducted, now that we've had that example.
I think that's a very good point. I mean, certainly, the people who would normally be, so to speak, on the activist side on human rights issues were also very much on the side of wanting more lockdown. I mean, I think in retrospect it's clear, and as this great inquiry rolls on, and as the sort of retrospective hostility to Boris grows and grows, it's clear that everyone now just wants to blame the Conservatives for this terrible misjudgment, or the whole string of misjudgments, forgetting that the Labour Party was calling for longer lockdowns.
Oh, so was everybody else.
At the time, and everyone else, and indeed opinion
including,
polls.
By the way, Nigel Farage. I remember him at the beginning,
I'd forgotten that.
You know, lambasting Boris for not locking down hard enough. We've been through the most extraordinary amnesia as a country.
Yes. So, so it's not a coincidence that there wasn't a great amount of outcry from human rights lawyers, because on the whole they tend to be on the progressivist, activist side of the equation. I mean, just think about it. How do you choose your career? It's the people who are sort of motivated to push further the boundaries of human rights that go into that line of law. You won't make your name as a human rights lawyer if you achieve some absolutely compelling judgment that actually pulls back on human rights.
But do you think that's a conscious choice? I mean, I'm struck when I return to occasional Gordies here, and I look at what are the people who are on the hard left as undergraduates doing now, Generally, some of them are working for the BBC and some of them are civil servants, but most are lawyers. And I wonder whether there wasn't a decision, I don't know, a conscious thought by some of them that they would be advancing an agenda that might struggle to get through at the ballot box, and with the bonus that you're a lot better remunerated as a lawyer than as a politician.
Yes, I think this is not to be excluded, though perhaps more as a sort of underlying, somewhat sublimated assumption rather than a sort of clever strategy to be pursued like some sort of personal conspiracy. But I think, yes, when I was reading through mountains of worthy-seeming treatises on human rights law by the academic experts, I was struck every now and then by extraordinary double standards. So I remember being struck by an article in a collected volume signaling to fellow human rights lawyers the danger that the author had noticed that the article that guarantees the right to liberty and security of the person, that word security, there was a danger in one or two recent legal arguments that people on the right had been using that to try to push for greater powers for national security. And the whole article was framed as literally just, how can we change...
They're muscling in on our thing.
How can we change the argument to stop that? So it was the opposite of what you and I might think an academic lawyer does, which is you look at the law and think, well, what are the consequences of the law? As it says, no. We want the law to be something else, or we want it to be impossible for it to do such and such. How do we close this down? And then on the other side of the equation, well, the same side of the equation, but looking in the opposite direction, you had articles by people saying, well, it's very unfortunate that economic and social rights are not actually contained yet in the convention. But here is a way of smuggling them in, which is under the right to private and family life and home life. There was a case in Belgium, a lady had failed to pay her electricity bill to a local electricity company. After many warnings, she was cut off. She then took the Brussels local government to court and breached her human rights. It should have ensured that she continued to get electricity and so on. And in fact, that was thrown out on somewhat technical grounds, and a whole article was written about this saying, well, surely this is the way that lies ahead. Social and economic rights can be brought in as necessary implications of having a home life. So you could expand this to being supplied with a certain level of food or healthcare, or all sorts of things that are not actually in the convention, but they're necessary in order to enjoy your home life or your private life. So sort of engineering of the law is actually in the lifeblood of some of the people who are influential in setting out, at least at the academic level, what it is that the lawyers in court should be thinking.
Yeah, and presumably that's intrinsic, isn't it? I think the Bishop Hoadley of Winchester 300 years ago said, whoever is the final interpreter, it is he, not who hath first spake or wrote it, that is the lawmaker. But I just wonder whether there is a change in our mentality as a civilization, that the law is now assumed to be this progressive force in a way that I don't think was the case 50 years ago.
Yes, I don't know. I mean, what the public wants of law is difficult to assess. You tend to get spasms on particular issues where the tabloids take up an issue and sort of, we must stamp out such and such. And this goes all the way back to the sort of headlines when Mrs. Thatcher was in power, when sort of Maggie acts. And this was part of a sort of tabloid way of approaching political issues. And it led on to knee-jerk legislation, the Dangerous Dogs Act and all of that. Beyond that, it's not clear what the public wants on a sort of broader horizon of its law. I think probably they want generally rather less law. And that's not what they're getting at all.
I mean, isn't this the first generation to have grown up with this? I'm very struck. I was writing a column today for tomorrow's Daily Mail about the report by the Home Affairs Select Committee in the House of Commons on the failures of the Home Office, and the failure in particular of the case of this Ethiopian asylum seeker who was improperly released and then tried to go back and wasn't allowed to go back to prison. One of the things that struck me is how recent all this is. You and I can remember a time before You know, it's not some immemorial part of the Constitution. And I was saying to you downstairs, I can remember our shock, you and I were both writing for the Telegraph at the time, at the case of the Afghans who came to this country illegally by diverting a plane at gunpoint to Stansted, and who then survived the attempts of 6 successive Home Secretaries from both parties to remove them. And at the time, we were really shocked by that. They'd arrived in 2000. The main legal case under John Reed, if I remember, was in 2006. And it struck us as extraordinary. It struck most observers as extraordinary that the British state did not have the capacity to remove people who had obviously committed a crime in coming here. Now, I put it to you, that would not strike people as unusual. We take it for granted. We treat the uselessness of our judiciary and our Home Office as just one of the things that you put up with in this country, like rainy Junes, or being knocked out of football tournaments on penalties, or and I think that is a change in one generation.
Yes, I mean, you used the word earlier, mentality, and I was thinking, I mean, your question was rather broad about law overall, but I think there has been a mentality change where the invoking of rights is concerned, and that's sort of germane to some of the things I was talking about. So, some of this has been internalized, that it's a much sort of, the speed with which people will resort to an argument from rights, I think that has accelerated. Get there in fewer steps now when you raise any issue. And what is the appeal of saying, but I have a right to it, or he has a right to do that? Well, part of the mentality goes back to that rights are trumps idea, which still floats around, and within a legal system, there may be cases where to some extent that is correct. But I think it's also on this question of whether these messy issues, the difficult issues, should be decided better by Parliament. I think there's obviously a sort of technocratic impulse that people would just rather, they've got used to thinking, well, we must get in the experts and they'll know what to do and they'll tell us. And what goes with that is a sort of growing disenchantment with democracy, or, one sees these rather shocking opinion polls where particularly young people, and in many, many advanced democracies around the world, don't think democracy is the best way to
I want to come on to that.
And then just finally, a mentality of, more broadly, of a sort of psychology of entitlement. It's very satisfying to say, but you've got to respect me because I have a right, or I've got a right because you've got to respect me.
And that is a phrase I don't remember hearing at all growing up. There's such a thing as human rights, right? I do remember hearing, as you will, the phrase, it's a free country. And the one has been displaced by the other. And it's your point, isn't it, about moving from negative rights to positive claims, that it used to be part of how we were as a people, that we would say, I'm allowed to do this because who says I can't?
Yes.
Into, I have a claim, I have an entitlement.
Yes. No, there have been changes. I mean, many years ago, I was invited just to a rather informal private meeting with the then Conservative, then Shadow Home Secretary and a senior lawyer about this general idea of producing a British Bill of Rights. And we went round in circles a few times, and I said, couldn't there be a rather simple British Bill of Rights? It would have one clause. It would say, every British citizen is allowed to do anything that is not forbidden by British law. End of Bill of Rights. I think they might have done better with that than the one they actually produced. Dominic Raab put in endless man-hours to produce a document which then rather fizzled out in the parliamentary process. And part of the error there was drawing in lots of human rights lawyers to draft it. I mean,
we do, of course, have a Bill of Rights. It's the closest thing we have to a constitution. But it's striking to me how even that is now set aside by activist lawyers. And I don't think we were as shocked as we should have been as a country by the Lady Hale judgment on the prorogation, which struck me as a very basic violation of the Bill of Rights, which says in very clear language, proceedings in Parliament shall not be subject to review in any court. I mean, I suggest that 10 years earlier that case could not have come to court. And she got around that, if you remember, by saying, well, it may have been a proceeding and it may have physically happened in Parliament, but it wasn't a proceeding in Parliament because there was no vote. I mean, come on. I mean, that really is just making it up as you go along. And when we've got to that point, it seems to me that the premise of your talk, which is we are a democracy, is in itself in the hazard, isn't it?
Yes, I mean, just on that judgment, I offer a small aperçu, and there may be sort of much better informed technical lawyers who can say more about this or disagree with it. But when I read that judgment, what I thought was driving the argument was something new in our constitutional law. Well, the whole thing was innovating massively constitutionally, but what it was actually a European doctrine of proportionality being applied to the heart of the British Constitution, which said not having Parliament sitting is a negative. And this negative can be allowed up to a certain point for permissible objectives, such as giving the poor MPs a summer holiday. But every day that it continues not to sit is a negative, and it has to be justified by being proportionate to the end for which... Suddenly you had this proportionality theory plunged into the heart of the Constitution in the crudest possible way. I just thought this is extraordinary, and it was the only central argument driving the thing. All the other arguments that pointed the other way in the previous judgment by three of the most senior judges in the land were not even discussed in that judgment. You know, the Master of the Rolls, the President of the Queen's Bench Division, and so on. This, I thought, was an unnoticed encroachment. Now, I say European proportionality theory. Of course, that doctrine extends further than the Strasbourg Court, and we're talking now about something that related to Brexit, and those, let's continue to keep those two things broadly separate. It's a popular misunderstanding that there's some essential link between the two. But I was struck by that, and I thought there's a sort of Europeanization of mentality going on there among the judges themselves.
I mean, I can't resist, and since you bring it up, I first came across you as a very early Brexiteer in the early 90s. You were one of what Dennis Thatcher called the long marchers, one of the people who was in it from the start. How much overlap do you think there is between the arguments one made back then for popular sovereignty and national democracy and the arguments against the ECHR and its related...
Well, as I said at the beginning, I'm not against internationalism. If the court had functioned as its original signatories intended, I probably wouldn't be saying any of these negative things about it. And at different levels of international law, there are all sorts of conventions, there are tribunals, there are regimes that people put themselves under, states put themselves under, and that all functions perfectly well. So I have no absolute a priori doctrine that says, you know, ourselves alone. On the other hand, quite a lot of what I was saying this evening was about the effect on democracy. And the essential reason why I was in favor of Brexit was just I wanted to live in a proper, functioning, representative democracy. And I did not think that was possible under a layer of supranational government of the kind that had developed and was continuing to develop in Europe. So for that reason, ultimately, I think there's a connection in my sort of inner psyche. But the actual arguments involved, I think, still stand some way apart.
We're out of time, but I can't resist asking you one final, very short question. How many languages do you speak? Let's use a historian's definition of being able to muddle your way through a source with occasional recourse to a dictionary.
It depends what you mean by speak. I'm a historian. I learn languages on a pragmatic, what I call the need-to-know basis. Do I need to know the subjunctive? Well, I might need to recognize it when I see it, but I probably don't need to have it in my head to produce it, because I'm not going to be having elaborate courtly conversations with people. I'm not going to be writing beautiful prose in the language. So I learn in a brutally pragmatic way, and I reach a reading level. And that, for me, suffices. But I don't have a number in my head.
Very good. Ladies and gentlemen, Dr. Noel Malcolm.
Thank you.